murder, but for the purpose of threatening Sir Horace if necessary in order to make good his escape. What is more likely than that Sir Horace heard the burglar in the house, crept upon him, and then tried to capture him? There was a struggle, and the prisoner, determined to free himself, drew his revolver and shot Sir Horace. Is not such a theory of the crime, that Sir Horace was shot while trying to capture the prisoner, more probable than the theory of the defence that Hill, the weak-willed, frightened-looking man you saw in the witness box, was a masterful, cunning criminal who for some inexplicable reason had turned ferociously on the master who had befriended him and given him a fresh start in life, had killed him and left the body in the house, and had then managed to direct suspicion to the prisoner? The theory of the defence does great credit to my learned friend's imagination, but it is one which I am sure the jury will reject as too highly coloured. Looking at the plain facts of the case, and dismissing from your minds the attempt to make them fit into a purely imaginative theory, I am sure that you will come to the conclusion that Sir Horace Fewbanks met his death at the hands of the prisoner. The junior bar agreed that the case was one which might go either way. If they had possessed any money, the betting market would have shown scarcely a shade of odds. Everything depended on the way the jury looked at the case, on the particular bits of evidence to which they attached most weight, on the view the most argumentative, positive-minded members of the jury adopted, for they would be able to carry the others with them. In the opinion of the junior bar, the summing up of Mr. Justice Hodson would not help the jury very much in arriving at a verdict. There were some judges who summed up for or against a prisoner according to the view they had formed as to the prisoner's guilt or innocence. There were other judges who summed up so impartially and gave such even balanced weight to the point against the prisoner and to the points in his favour as to make on the minds of the jurymen the impression that the only way to arrive at a well-considered verdict was to toss a coin. Another type of judge conveyed to the jury that the prosecution had established an unanswerable case, but the defence had shown equal skill in shattering it, and therefore he did not know on which side to make up his mind. And fortunately English legal procedure did not render it necessary for him to do so. The prisoner might be guilty and he might be innocent. Some of the jury might think one thing and the rest of the jury might think another. But it was the duty of the jury to come to an unanimous verdict. It did not matter if they looked at some things in different ways, but their final decision must be the same. Mr. Justice Hodson belonged to the impartial, impersonal type of judge. He had no personal feelings or conviction as to the guilt or innocence of the prisoner. It was for the jury to settle that point, and it was his duty to assist them to the best of his ability. He went over his notes carefully and dealt with the evidence of each of the witnesses. It was for the jury to say what evidence they believed and what they disbelieved. There was a pronounced conflict of evidence between Hill and Fanning. They were the chief witnesses in the case, but the guilt or innocence of the prisoner did not rest entirely upon the evidence of either of these witnesses. Hill might be speaking the truth and the prisoner might be innocent, though the presumption would be, if Hill's evidence were truthful in every detail, that the prisoner was guilty. Fanning's evidence might be true as far as it went, but it would not in itself prove that the prisoner was innocent. Hill had admitted that he had drawn the plan of Riversbrook to assist Birchill to commit burglary. It was for the jury to determine for themselves whether he had been terrorised into drawing the plan for Birchill, or whether he was the instigator of the burglary. The defence had contended that Hill had drawn the plan at his leisure, at a time when he had access to a special quality of paper supplied to his master. If that were so, Hill's version of how he came to draw the plan was deliberately false and had been concocted for the purpose of exculpating himself. But they would not be justified in dismissing Hill's evidence entirely from their minds because they were satisfied he had perjured himself with regard to the plan. They would be justified, however, in viewing the rest of his evidence with some degree of distrust. Counsel for the defence had made an ingenious use of the facts that the body of the victim was fully dressed when discovered and that none of the electric lights in the house were burning. These facts lent support to the idea that the murder was committed in daylight, but they by no means established the theory as unassailable. They did not establish the innocence of the prisoner, although to some extent they told in his favour. Counsel for the prosecution had put before them several theories to account for these two facts consistent with his contention that the murder had been committed by the prisoner. The jury must give full consideration to these theories as well as to the theory of the defence. They were not called upon to say which theory was true except in so far as their opinions might be implied in the verdict they gave. The defence, continued His Honour, was that Hill had committed the murder and had then decided to direct suspicion to the prisoner. If the jury acquitted the prisoner, their verdict would not necessarily mean that they endorsed the theory of the defence. It might mean that, but it might mean only that they were not satisfied that the prisoner had committed the murder. If the jury were convinced beyond all reasonable doubt that the prisoner had committed the murder, they must bring in a verdict of guilty, and if they were not satisfied they must bring in a verdict of acquittal. The jury filed out of their apartment, and as they retired to consider their verdict, the judge retired to his own room. The prisoner was removed from the dock and taken down the stairs out of sight. There was an immediate hum of voices in the court. Inspector Chippenfield approached the table and whispered to Mr. Walters. The latter nodded affirmatively and left the courtroom in company with Mr. Holymead. The sibilant sound of whispering voices died down after a few minutes, and then began the long, tedious wait for the return of the jury. The occupants of the gallery, who had no difficulty in coming to an immediate decision on the guilt or innocence of the prisoner, could not understand what was keeping the jury away so long. They failed to understand the jury's point of view. These gentlemen had sat in court for 3 days, listening intently to proceedings concerning a matter in which their degree of personal interest was only a form of curiosity. And now the end of the case had been reached, except for the climax, which was in their control. To arrive at an immediate decision in a case that had occupied the court for 3 days would indicate they had no proper realisation of the responsibilities of their position. A verdict was a thing that had to be nicely balanced in relation to the evidence. Where the case against the prisoner was weak or overwhelmingly strong, the jury might arrive at a verdict with great speed as an indication that too much of their valuable time had already been wasted on the case. But where the evidence for and against the prisoner was fairly equal, it behoved the jury to indicate by the time they took in arriving at their verdict that they had given the case the most careful consideration. 2 hours and 20 minutes after the jury had retired, the prisoner was brought back into the dock. This was an indication that the jury had arrived at their verdict and were ready to deliver it. The prisoner looked worn and anxious, but he received encouraging smiles from his friends in the gallery. A minute later the judge entered the court and resumed his seat. The jury filed into court and entered the jury box. Amid the noise of barristers resuming their seats and court officials gliding about, the judge's associate called over the names of the jurymen. The suspense reached its climax as the Associate